start. So welcome everyone to this online seminar, which is going to focus on right to work checks. I'm Andrew Osborne. I'm the partner and head of the immigration team at Silkin, and we'll be joined today by Tom, who's an associate who covers employment law issues and immigration, and Lee, who's another member of the immigration team. So there are pictures of us before we started working from home. So after 8 months, we probably look slightly different. I'm not sure for the better, but I'm just speaking for myself. But that's how we used to look when we went to the office every day. And in terms of a few housekeeping points, so everybody who's attending is on mute. And in terms of the seminar, we are recording this, and we're going to also make the materials available to everybody. If you have questions as we go, please use the chat function. If we do have time at the end of the session, we can answer some of those, but we'll also be putting together a Q&A, which will also circulate the materials to deal with questions that people have, because obviously this is quite a tricky sort of area, and there are some changes coming up. So yeah, but please put your questions into the chat function. So in terms of what we're going to cover today, the first section Lee will deal with, which is really looking at the history of right to work checks and a refresher on how manual checks are made. Then there's a bit of an update in terms of the move to online checks, where employers can actually access Home Office records, which will hopefully be better in terms of clarity for employers about people's status, what changes and concessions have been made because of COVID, how the employer checking service could be helpful, and then just some outline on avoiding race discrimination when doing checks. But Tom is going to sort of look more at those sort of issues later. Then I'll be dealing with the situation with EEA nationals, and we have a difficult situation at the moment where we're going to have two systems overlapping, where we have people who have taken up residence by the end of this year who qualify to register under the EU settlement scheme, and then people who come to the UK from the 1st of January who will need to qualify under the UK's new immigration system. Problem is we'll have an overlap between the registration deadline, which is the end of June 2021, and the application of the new UK immigration system. So it might be difficult during this 6-month what's called grace period for employers to actually be clear about what someone's status is, whether they took up residence before the end of 2020, or whether that's an employee who needs permission to work under the new immigration system. So we'll have a look at that issue and give you some tips about how to deal with that. And then Tom will look at some of the employment law issues around how you deal with right to work checks sensitively, what actions you can take. Obviously, there are always discrimination risks when looking at right to work checks, so he'll go through that. And then he'll also deal with some of the sort of frequently asked questions we get in this area. So I will now hand over to Lee, who will take you through the right to work check.
Thank you, Andrew. Good morning, everybody. I hope you can hear me okay. So my part, I will be talking about the history of right to work check and how the current practice looks like. So first, you can see on the slide that we only introduced the civil penalty from 27 January 1997, and before that, there's no checks required for employers. And over the last more than 2 decades, and you can see the statutory excuse was established. The criminal liability has been introduced to employers, and which is up to 2-year imprisonment. And also from last year, 28th January 2019, the online right to work check was introduced, and basically it's pretty much most of them for the EEA nationals. I will talk about this in more detail later. From this year, 30th March, due to COVID-19, obviously, we had a lockdown, and now we are still in the second lockdown in England. So Home Office has confirmed the rule have some sort of flexibility in terms of right to work checks. I will talk about adjusted remote right to work check later. So before I go into the manual right to work check, mainly there are two methods to carry out right to work check. One is manual right to work check, one is an online right to work check. And it is for employers to carry out right to work check, and it can't be delegated to agents or legal representatives. It has to be done by employers. And for some employers, some companies, you may have agent workers. So if they aren't your employer, so their employee, if they aren't your employees, their employers should carry out right to work check before they send those agent work to your company. But we also recommend you to just carry out the right to work check as normal, just to prevent any reputation damage in case it turns out this person didn't have right to work or their employers didn't carry out the right to work check. So the process itself is very simple, 3 steps. So first step, you request documents from employee. Second, you check the documents. And third is you copy, certify, and keep the documents. There are key points here. First, you need to request original documents from the employee, and you check the original document in front of the employee, so it has to be in person. And obviously, you copy, you certify, you keep the documents. So when you carry out right to work check, you need to know what kind of documents are acceptable for the Home Office in terms of, carry out the right to work check appropriately. So now we're going to look at what kind of documents are acceptable. There are two lists, List A and List B documents. So List A is pretty much for the people who are British or who are EEA national, Swiss national, or people simply have permanent residence or indefinite leave to remain. So basically, they have settlement in the UK. And you need to check those documents before the employment starts. And you don't need to check again because it's a settlement, so you don't need to check it again. There's no expiry date. And the key here is that for certain people, they may had indefinite leave to remain endorsement in their old passport. It was okay, it was acceptable if this person started working with you before 16th May 2014. But if someone joined you after 16th May 2014, you have to make sure the indefinite leave to remain endorsement is in their current valid passport. It also means most of the case, they need to show you a biometric residence card, a biometric residence permit, like an ID card, instead of endorsement in their passport, in their old passport. So make sure you check when this person actually start working with you, whether the old endorsements in their previous expired passport still available, still acceptable, or you have to check, ask them to get a BRP card before they can start working for you. So the List B Group 1 document is it is for people who have a limited period, a limited visa. For example, typically we are talking about the Tier 2 general visa, or Tier 2 ICT visa, or any non-EU national family members who has a family permit or who has a residence card. So basically, it is a visa has expiring date for 2 years, 5 years, 3 years, something like that. So you need to make sure you check before their employment starts and also before the expiring date of their visa. So of course, as good practice, you might want to put in your diary, make sure you check, 1 month or 2 months before the visa expires. So you need to make sure you have a record what you need to check and when you need to check. And some of you may have seen recently the visa itself valid for 5 years beyond 2024, but the BRP card itself has expiring date of 31st December 2024. It doesn't mean that visa duration has been curtailed. It basically means, I think from 2025 that may be another format of visa. So that's why they can only give you that period. After 2024, they will introduce a new format of visa. So this is not about their expiry date. So you don't need to check before 31st December 2024. You only need to check before the actual visa expiry date. Okay, so in terms of this B Group 2 document, it is about, for example, people have submitted their application, but obviously due to COVID, due to other reasons, it takes quite a long time for the Home Office to application, or unfortunately the application has been refused, and the individual decided to go ahead with appeal or with admin review. So that's something, it basically means that the application itself hasn't been finalized in terms of having a final decision yet. And you need to check having those kind of evidence to show that this person actually has a pending application or has submitted appeal or admin review. And also you need to get a positive verification notice from the employer checking service, which is an online checking service with the Home Office, and make sure you have positive notification. So basically, Home Office acknowledged there is a pending application or there is appeal pending or something like that. So you know this person actually has a right to work in terms of a 3C leave. And the positive verification notice only valid for 6 months. So if within the 6 months this individual hasn't got a decision on their applications, then you need to carry out another check with the employer checking service. Okay, so we talked about manual right to work check, and second method is online right to work check. It's pretty much a similar step, 3 steps as we talked about manual right to work check. The key difference here is that the individual employees won't get actual BRP card or actual visa endorsement in their passport. What they got is approval letter with an online link from Home Office, and the individual employee will need to log in and basically provide a share code to you as employer, and then you can use that share code to check this person's visa or status. For example, typically pre-settled status or settled status for EU national, Swiss national. And you can check the status online, but you still need to see this person in person, in person in front of him or her to check the passport and the online status as well. So again, you have to copy, certify, and keep documents. as well. So that's slightly different to what we talked about in terms of manual right to work check. So obviously this year because of COVID-19, most of us are working from home for so long, and we can't really meet people in person. So therefore, Home Office has introduced this adjusted manual process, right to work check for due to COVID. So what you need to do, obviously, you can't see people in person. What you need to do is you ask this person, you ask the employee to provide you a copy of their visa and copy of their passport. And then you schedule a video call with the individual, ask them to hold the original document, on a screen, so you can check whatever copies you received against the original you see through the screen. So make sure everything is in order. There's no different information on the copies, as well as the photo you see through the screen. So that's something you need to check. And after you are satisfied with the documents, then obviously you make a copy, you certify, and make sure you include wording such as adjusted check undertake on, say, 1st December due to COVID-19. So this is something you need to do as a flexible right to work check due to COVID-19. And we talked about employer checking services, the service. You don't need to use this service for people who have already got a visa. You only need to use the service if someone has pending application, or someone cannot give you evidence to show they had a visa, or they have a valid visa. So you need to check with the employer checking service. Before checking, make sure you get permission from the individual to tell them this why you need to use this service to check their immigration status. And normally it is an online process. It's very simple. Most of you may have already done this. So you need to individuals' information and put the details in. Normally, Home Office will respond to you within 5 working days. Recently, we have seen slightly longer processing time, but normally that's what their guidelines is. And once you get the verification notice, either positive or negative, positive verification notice, it only valid for six months. So if someone hasn't got a visa within the 6 months, you need to carry out another employer checking service there as well. Okay, so at the beginning we talked about the Home Office has introduced statutory excuse. So now we're looking at which right to work check can be covered, can provide a statutory excuse. So obviously, online check and manual check we talked through can provide a statutory excuse. The key is you have to carry out the right to work check correctly. So that's the key. And in terms of the flexibility, the flexible adjusted check due to COVID-19, unfortunately, they don't provide a statutory excuse. So what you need to do is that currently we are still under this lockdown. We don't know how long it's going to be. We're going to be, back to the tiered lockdown regionally. So that's something we don't know when Home Office will announce that, look, the COVID-19 adjusted check ends. So once that announcement is made, employers have 8 weeks to go back to all those checks during this flexible check, back to either online check or manual check in order to have a statutory excuse. So that's something, be aware of that. But I don't think, the official announcements from Home Office will come that quickly, because obviously due to the current situation, we think it will be beyond next year, beyond this year as well. So in terms of when you carry out right to work check, you need to make sure there's no issue in terms of race or discrimination or anything like that. So my colleague Tom will talk about this in more detail from employment law perspective. So I will leave that to him to talk about. Okay, so this is my last bit. This is just some general tips to avoid any pitfalls. So first, be mindful that who you need to carry out right to work check, who you don't. Like I said, in terms of agent work, if they aren't your employee, you do not have a duty to carry out right to work check. But good practice is carry out right to work check just to prevent any reputation damage. And some people, they aren't agent worker, they aren't stand from agency. They may be a self-employed contractor working for you, but in that case, you need to make sure right to work check is carried out before the individual start working for you. And also in terms of do not assume that a negative verification notice from employer checking service means the person doesn't have a right to work. Sometimes when Home Office receive application from an individual, sometimes it does take a couple of days or even longer for the Home Office to lodge all those information into their system. Therefore, there might be a 3 days gap. You may not get any, instead of positive notice, you got negative, simply because they haven't input all this information into their system. So do not just assume that. You may want to carry out another check in a couple of days' time. And also be aware that you may face a tribunal claim if you dismiss somebody on the basis of unreasonable view that they didn't have right to work check. So this is something that Tom will talk about a little more later as well. Okay, so now I'm going to I'm going to ask Andrew to talk about the right to work check in terms of EEA national. Just here you go, Andrew.
Great, thanks, Lee. So I'm going to sort of talk about the specific situation that we have with EEA nationals and focus on this grace period. So January to June 2021, where there is this lack of clarity about an EEA national's status and what checks an employer would need to make to confirm someone's right to work. And my sort of starting comment is that the current position is extremely unsatisfactory for employers. It puts employers in a very difficult position. We are hoping and I think I'm fairly confident that the Home Office is going to provide further sort of guidance in terms of this situation. But what we're going to do now is sort of just set out the current position and then some sort of tips as to how to deal with the position for the next sort of 6 months from January to the end of June. Once we get past June, things will be much clearer about what paperwork you need to see. But in the interim, there's a few ideas about how to deal with this matter. So at the moment, right to work checks for EEA and Swiss nationals and their family members remain the same as they currently are. So as Lee set out, looking at a passport or an ID card, and that stays the same until the end of June 2021, which is the end of this grace period. Irish nationals are considered separately from other Europeans because they have a different status in the UK. So the checks for Irish nationals will still remain the same as they are now, where you can just see a passport. Now, at the moment, the Home Office is saying that employers don't need to conduct retrospective checks for any EA nationals and their family members to start work before the 1st of July 2021, which is on the one hand helpful, but on the other hand, it doesn't help an employer know what the status of an employee is. So I think that is something we need clarity on. Exactly, if you don't need to do retrospective checks, how does an employer confirm someone's right to work? The Home Office have said that they think that the hostile environment, so the need to provide proof to a number of different bodies. So if you like to open a bank account or rent property, you have to prove your right to be in the UK. They believe that that will encourage people to have proof of their status in the UK and to basically get the paperwork they need. And it's also said that it doesn't intend to penalise employers by issuing civil penalties if someone is found to be working illegally. So again, that's helpful. But what the Home Office haven't done, that last bullet point, so where an employer comes aware or should be aware that an EA national or their family member doesn't have the right to work in the UK, that's normally as criminal, potentially it's a criminal offence and can be prosecuted. What we haven't got is clarity about whether the Home Office are going to also take a much more flexible approach to that sort of situation where an employer basically just doesn't check someone's right to work. And that sort of goes back to the second point there, saying you don't have to make retrospective checks, but what happens if you become aware that somebody who hasn't been checked shouldn't be working in the UK. So we need a bit of clarity around quite a few of these areas at the moment. So, as I said, the Home Office are aware that employers are unhappy and are anxious about making sure they're compliant, and we have been promised some more detailed guidance about how to deal with this grace period in terms of what paperwork can you accept, or whether they'll, for example, just be a complete sort of moratorium on right to work checks for this 6-month period. So we wait to see exactly how the Home Office wants to deal with it. But there are a few tips in terms of how we think or what a good approach would be to give yourself the sort of maximum protection. So the first thing is to maintain an open dialogue with EA employees and any family members who are here on the basis of their relationship with an EA national. So leading up to the end of this year and then after the end of this year, sort of up until the end of the grace period, and just remind people of the various ways that they can prove their right to work in the UK. So as we said, European passports or ID cards are fine as proof of right to work during the grace period. Again, just note Irish citizens will still be able to rely on passports after the end of the grace period. If you're a family member of an EA national, you may need residence documentation. And the EU settlement scheme is the way that going forward people will prove their right to work in the UK. So once the grace period ends, proof of registration under the EU settlement scheme will be a right to work check. But again, just encouraging people to say that that is something that you can do. And in some ways, the earlier you do it, the better, because then you have proof of your right to be in the UK. Where people your EA nationals don't take up residence before the end of this year, they'll need to provide proof of their right to work under the new immigration rules that come into force for the 1st of January. And then there's also a new permit for those who sort of commute to work in the UK, a frontier worker permit, which will also become something that people can use to prove their right to work. So there are going to be various options, and it's just letting people know what those options are. In terms of approach, there's a slightly differing approach depending on whether you're dealing with existing employees or new recruits. So for existing employees, we suggest that emails are sent to all employees before the end of this year and then after the end of this year, so early in 2021, basically offering support to those that need to register under the EU settlement scheme or require a frontier work permit. You could also talk about this new online right to work check, as Lee sort of set out, as that is the way that the Home Office wants employers to make these checks going forward. And then as we get into 2021 and closer to the end of the grace period, communication become a little firmer in terms of letting people know that from the 1st of July, people will need to prove their right to work. And again, it would just be helpful to have the paperwork that you as an employer will need to see once the grace period ends and have that available. So that would be a sort of suggested strategy for existing employees. And then where you've got new joiners, again, I suppose the second point on that slide is the one to emphasize that you've got to make sure that communication is consistent with all prospective new joiners. As Tom will outline, there are some various potential discrimination issues. So just being consistent with communication, but again, highlighting to new joiners that there is going to be a requirement to prove your right to work. Again, setting out the various options people have to demonstrate their right to work. If people need assistance in registering under the settlement scheme, or if they need to apply under the UK immigration rules. But really, again, just setting out very clearly to people at the same point in the recruitment process what options they have for right to work paperwork and offering them support to get it if it's required. And then there's just a few tips. As I said at the outset, this situation isn't ideal for employers. There is a degree of confusion, which we hope will be cleared up by the Home Office. But at the moment, because EA nationals have until the end of June 2021 to register under the EU settlement scheme, you aren't able to demand that they show proof of having registered until the 1st of July, because there is still an option for them to register. So just be aware of that if they're happy to show that proof, then that's great, but it's just being careful about how communication is worded. Again, Irish nationals are sort of separate to this exercise, and you can rely on previous right to work checks where they've shown a passport, or if you have a new recruit that's an Irish citizen, they can again just show you the passport. Even though it's an issue for a lot of employers, and it's a difficult issue, just to avoid being overly enthusiastic about your communication or overly harsh about requiring people to show you right to work documentation. So it's treading a line, and Tom will sort of go through from an employment law perspective kind of where these lines are drawn. And also just have a plan around communication. And in general terms, our view is that you can have helpful communication, which becomes perhaps a little more strident as we go through the grace period. And towards the end of the grace period, obviously it's in your interest and the employer's interest to be able to prove their right to work. So I think there's a kind of a gradual approach where things are sort of ramped up towards the end of the grace period next year. And just to let you know, we do have some template emails that we're happy to offer to people to send out to staff to really set out the position and their obligations and the sort of timing of the availability of new documentation. So that were a few tips. I'm going to
Andrew,
sorry, yeah.
Thank you, Andrew. I just noticed we got quite a few questions, so
Okay.
May just to give 3 or 5 minutes to go through some questions, if you don't mind. I think first question was, we had a Bulgarian national on our payroll who has been furloughed since March, and she is with her family in Bulgaria. and she will be continue working for us next year. But if she comes in, if she's still in Bulgaria next year, on the 1st of January 2021, will she need a visa to continue working for us or not? Do you want to answer? Do you want me to?
Yeah, no, I can answer that. So
sure.
if that person has been resident in the UK, which they clearly have before the end of this year, then they're eligible to apply under the EU settlement scheme, and we'd highly recommend that they do that. You can actually make that application from outside of the UK, but you have to have sort of proof of your residence here. Secondly, if that person is going to come back before June 2021, they can actually still apply under the settlement scheme until that date because they have taken up their residence before the end of this year. But in that situation, it would be very important that they do register to retain that right, in essence, their free movement right, because if they don't, then they may need to qualify under the UK's new system. But I think there's no reason why they couldn't apply under the settlement scheme.
Great, thank you. Another question is about adjusted right to work checks due to COVID-19. So basically, it asks, we have been doing the verification via video call, but I haven't taken any screenshots. And I think another similar question on that. So I'm not 100% sure about what the screenshots refers to. You know, in terms of copy of the passport and the visa, of course, you have to have those copies. If obviously they are sent to you via email, so you should have them, that's fine. And once there is official announcement telling us that the COVID-19 check, right to work check, and then you have 8 weeks to go back to what you have done from March 2020 to either carry out a manual right to work check or online right to work check. There is another question about, Andrew, I think this is about EA nationals. Would you recommend company communication on the immigration changes to include signposting? We have internet where we can post things like this, but I'm not sure if we should do more wider ones.
I think as much communication as possible is helpful at this stage, because obviously this is a very significant shift, and from the 1st of July, from an immigration perspective, things will be very different. So I think people need as much warning and as much information as possible. So my general view is the more channels of communication and the more resource can be offered to employees, the better at this stage, just because it's vital that people are aware of what the changes are and how these can impact them, and also what can they do to secure their status in the UK if they want to stay living and working here.
Great, thank you, Andrew. I think there are a couple of questions about automatic dismissal or suspending without pay. I think my colleague Tom will talk about this when he goes through his slides as well. So I think I'm just conscious about time. Now, Andrew, do you mind move the ball to Tom, please?
Yep, that's done.
Thank you.
So I'll just hand over to Tom. Thanks.
Hi everyone, I hope you can hear me okay. My name's Tom. As Andrew mentioned at the start of the presentation, I actually sit across both the immigration and the employment teams at Lewis Silkin. So I wear 2 hats, and I sometimes have to advise clients on tricky areas where immigration and employment law intersect and unfortunately often conflict. So this is just going to be quite a brief canter through those sorts of questions, those sorts of scenarios that pose particular headaches for our clients. It's a big area, and necessarily each case will sort of differ from case to case, facts are never the same, clients' objectives are never the same. So it's really just an overview so that you're aware of some of the issues that crop up in these areas. But we'd always say, make sure that you're thinking through your specific approach before you rush to make any decisions. So I hope that that sort of broad message will come through in this section of the presentation. So first few bullet points should hopefully be familiar to you now based on what Andrew and Lee have been talking about. Right to work obligations come from immigration law, which sits separately to employment law. It's obviously an offence to employ a worker who doesn't have the right to work in the UK, or where you have reasonable cause to believe that they don't have the right to work in the UK, and there are risks of penalties and other sanctions if you are employing someone who doesn't have the right to work in the UK. But those employees will also benefit from employment rights under UK employment law, and the two areas of law can come up in conflict with each other. So the key takeaway that I want to kind of get across in this session is you have to be on top of this. You have to be handling them decisively. You have to be coming to clear conclusions and in good time if possible. That's not always the case, but preferably in good time, but also handle them sensitively, carefully and cautiously. So for new hires, the employment law position is relatively straightforward. You should be making your offers of employment conditional on the individual being able to prove that they have the right to work in the UK, being able to show their documents. So we would suggest some wording in the offer letter along the lines of the wording in the second bullet point there. And we would also very much recommend strengthening your employment contracts if you don't have wording like this already, essentially saying that it's a condition of employment that the employee is able to prove that they have the right to work in the UK, they're able to show that they have their documents, and that essentially a breach of that term will in effect kind of cause problems for their continued employment. Those are things which will help you in the event of a tricky situation, which I'll come to in a bit, where you have a suspicion that an employee doesn't continue to hold the right to work in the UK. If you, with a new individual, a new hire, they aren't able to show that they have the right to work in the UK, they're not able to produce their documents in line with the Home Office guidance, the withdrawal of that offer will not create a risk of unfair dismissal. So unfair dismissal is all about the fairness of the dismissal. There's no risk of an unfair dismissal claim because they won't have 2 years service. You need 2 years service to bring an unfair dismissal claim, and necessarily a new hire doesn't have that. But we have to flag that there is a risk of a discrimination claim. You can bring a discrimination claim from day one of employment. In fact, you don't even need to have started employment to bring a discrimination claim. You can bring a discrimination claim against a company for discriminatory behaviour in the interview, for example. So there is a risk of discrimination, a risk of a discrimination claim if you act too hastily and in a way that is inconsistent with the way you would treat other new hires. I'll flag some specific discrimination risks as my section goes on. So this is probably where I get the most queries in this area. Often there's a great degree of panic because it will have been discovered that a current employee is unable to show that they have a continuing right to work in the UK, or it certainly seems to be the case on the papers. And it's really important to treat that situation very carefully, very sensitively. There will be much more risk than with new hires because of the possibility that the employee has at least 2 years service and are therefore able to bring an unfair dismissal claim. But tempered with that is the need to act quickly. So you do need to act quickly, but it is difficult to immediately stop employing employees. I saw we had a question in the chat about European workers who are unable to show potentially unable to show that they have pre-settled status or settled status under the settlement scheme on the 1st of July 2021 onwards. I believe the question was along the lines of, can we automatically stop employing them? Can we immediately suspend them? I hope that this talk will show that there is a significant degree of risk in pursuing down that sort of avenue, although obviously completely sympathise with the difficulty that employers face in that situation. So, employment law says that if an employee has 2 or more years service, they have the right not to be unfairly dismissed. Unfair dismissal has a number of components. You need to be dismissing for a potentially fair reason, and illegality is a potentially fair reason. So if an employee doesn't have the right to work in the UK, then you are entitled to dismiss and rely on illegality as a potentially fair reason. There are a number of issues around that though. The first one is that that's not enough in and of itself. There is still a need to act reasonably in the dismissal. And secondly, and I think this is one of the points that often comes up when I'm giving clients advice in this area, is it's not always clear-cut whether an employee actually has the right to work in the UK or not. It may seem like they don't, but if they in fact do, their dismissal will create some risk if you then, in an employment tribunal claim for unfair dismissal, attempt to rely on illegality as the reason for dismissal. You may actually have the right to work in the UK all along. You will not be able to rely on the illegality reason. There is also discrimination risk, as I've mentioned before, and I'll come back to it in a bit. So, what do you do where you are asking for evidence of their right to work? Let's say it's a tier 2 visa. Maybe this employee has slipped through the net, and you give them clock that they needed a renewed application for a skilled worker visa, and they can't provide evidence of their continuing right to work in the UK. From an immigration perspective, from an immigration law perspective, you need to be thinking about where this is going to end up, and you need to be entertaining the idea that this employee is not going to be an employee of yours before too long. But from an employment law perspective, you have to be aware of the risks and you have to be following the process. So what does that process look like? First, and very importantly, you need to be investigating. The quality of your investigation will be something that the employment tribunal, if faced with an unfair dismissal claim, will be considering as part of whether the ultimate decision to dismiss was reasonable or not, was fair or not. And where possible, start with plenty of time. The reason is obvious. When you're dealing with, if the horse has already bolted, if you've already discovered that an employee potentially doesn't have the right to work in the UK, the date on their BRP, for example, has long passed, then you are already sort of swimming against the tide, as it were. If you're able to start the investigation with plenty of time, gives you lots of time to think through the issues and to ask the relevant questions. Correctly identifying whether an employee no longer has the right to work in the UK can be difficult. That's the point that I touched on. It's not always clear-cut whether or not an employee actually has or doesn't have the right to work in the UK. So talk to them, explain the situation, hold meetings with them, and use the employer checking service, which is something that Lee brought up before, and of course you do have a 28-day grace period to sort out an employer checking service check. If you receive a negative verification notice, the obvious inference is that the employee doesn't have the right to work in the UK, but there can be mistakes made, or they could have the right to work in the UK through another route that wouldn't come up on the employer checking service. For example, they may have made an application linked to their status as a family member of an EEA national. So it's really important to do everything you can and to try and come to the best conclusion with the best information possible. And I would stress that you need to be coming to your own conclusion, not solely relying on, for example, a negative verification notice that comes through from the employer checking service. Suspension. Suspension is always asked in this area. I would say that in 9 times out of 10, rule of thumb, it's not appropriate. Suspension is very much considered sort of an action of last resort. And to be honest, it doesn't even really alleviate the problem of potentially you have someone on your books who doesn't have because they're still employed by you. So I can't really see scenarios in which suspension with pay is because the fundamental employment law position about suspension is that it is generally something which is only justified in exceptional circumstances. If there's no reasonable explanation or evidence given by the employee, you can start to think about dismissal. And as I said, you need to identify a potentially fair reason for dismissal. So you will be relying on this as the last bullet point here, the reason being illegality. But you're only able to rely on that, as I said, if they actually didn't have the right to work in the UK. Whether or not someone has the right to work in the UK or not is a completely binary issue. They either do or they don't. So what you want to be able to do is rely, in the event of an employment tribunal claim, on an alternative argument. So you say to the tribunal, in the event that the employee did actually have the right to work in the UK, we would still like to rely on the reason for dismissal being some other substantial reason, which is another one of the given potentially fair reasons for dismissal under employment law. But you want to be able to show that you had a genuine belief that they didn't have the right to work in the UK, even though it was mistaken. And that's where the quality of the investigation, the amount of correspondence and communications, investigation that you have with the employee comes into it. So you need to be firming up your investigation as much as possible. This also comes back to where the point that I mentioned with new hires. You have wording in your employment contract that stresses the fundamental importance of having and being able to demonstrate the right to work in the UK. That's all good stuff. That goes into the pot. A tribunal judge will be much more likely to find in your favour and find that the dismissal was fair for some other substantial reason if you have all that stuff in place. Notice, I don't really have a huge amount of time here. I don't want to labour the point. It's a bit of a vexed issue because strictly as a matter of law, if they don't have the right to work in the UK, there is no need to give them notice or pay them notice. But if they do have the right to work in the UK, as we just discussed, it's not always clear cut whether they do or don't. The failure to provide notice, so either have them work their notice, which is generally not something I would advise where there's any doubt because they're continuing to be an employee. But if you're paying in lieu of notice, which is the quickest and easiest way of getting someone off your books, if you don't pay in lieu of notice that they actually did have the right to work in the UK, then you're potentially faced with a wrongful dismissal claim. Wrongful dismissal, remember, is different to unfair dismissal. Unfair dismissal is about the fairness of the dismissal. Wrongful dismissal is about notice. So I don't want to go over the point because it's a notoriously vexed issue. It will often come down to the client's appetite to risk and the risk of facing a wrongful dismissal claim. Offering the right of appeal can be a very helpful get out. So if you dismiss, you say you have the right to appeal, you're no longer an employee from this date, but if you are able to produce acceptable evidence of your right to work in the UK, we will reinstate you. That helps to mitigate the risk of an adverse compensatory award being made against you in an unfair dismissal claim. So my general rule of thumb to clients is employment law risk, very important. Immigration law risk, very important. Where they conflict, I would tend to say go with the immigration risk. That usually has far more severe penalties than the risk of facing an employment tribunal claim. But employment law risk, still very important, worth thinking through very carefully. And when you do have any questions, please just pick up the phone and give us a ring. Each client's case will be different. Each client's objectives, commercial objectives, will be different on a case-by-case basis. So here are a couple of questions that I do get asked. Discrimination, I don't want to get into the whys and wherefores of discrimination here. We don't have the time. I think the important takeaway from this section is there is discrimination risk when dealing with right to work checks, whether you're talking about new hires or existing employees. Remember that you don't need 2 years service, you don't need any service, you don't even need to be an employee to bring a discrimination claim. Broad rule of thumb, broad principle of guidance here, if you're treating all employees equally, the risk of a successful discrimination claim being brought against you should be low. If you're not differentiating in any way between employees, then the risk necessarily should be low. However, in practice, that is difficult. The immigration regime is, by its very nature, discriminatory. It discriminates between, well, for the next month, we have discrimination between UK and EEA nationals in one pot and non-EEA workers in another. And obviously, after the new year, the EEA nationals get pulled into the second pot. So it is an inherently discriminatory regime, so it's very, very difficult to navigate the discrimination risks in this area. Importantly, don't be making assumptions about whether they'll be able to provide their right to work. Don't be making assumptions based on their appearance, their language ability. Be conscious of unconscious bias. There are ways in which we sort of incorporate discriminatory assumptions about people, and you're going to want to be careful of that, because it may be that you can get away with it in a discrimination claim, but it may be that the employee is able to adduce a whole raft of evidence that shows that there were these other times when you behaved in a way that might lead to an implication of racial discrimination. They may not win with this, but the point is to try and hedge off the risk of a claim being brought even in the first place, so you can avoid that headache. There was a case a little while ago now involving the law firm Osborne Clark, where they essentially had a blanket refusal to consider applications from people who would require a work permit. And this is a question I'm actually getting asked a bit now in the context of a post-Brexit immigration system. Can we have a blanket refusal on hiring people who aren't able to demonstrate their right to work in the UK? The answer from the Osborne Clark case, which went to the Employment Appeal Tribunal, is no. You shouldn't be having that blanket case. That is discrimination. You shouldn't be preventing someone from submitting an application if they don't have the right to work at that time. You can, this is what the Home Office guidance says, you can ask candidates to provide evidence of their right to work in the UK at any stage before they actually start work. So that might be right at the end when you've made the offer, or it could be a bit earlier. It could be at the final round of interviews. It could even be all those called to a first interview. Importantly, you need to be doing it with everyone. And if the candidate doesn't have the right to work in the UK, this is the message that comes from the case law in this area, you can consider sponsoring them, but you're not obliged to. So a failure to decide to sponsor someone will possibly not be discrimination, depending on what's gone into the pot. The Home Office is clear on that. But again, very, very important to nail down exactly what you're doing and the exact reasons that you're giving to individuals for your decisions. Very, very briefly, TUPE is another topic I get asked about. It's really just what it is on the slide. Where there is a TUPE transfer, the buyer is inheriting the liability for right to work checks that have been done by the seller, and buyers are advised to carry out right to work checks on all transferring employees. And indeed, we'd be advising that in the course of your corporate due diligence that you'd be asking questions about the immigration status of employees. There is a 60-day grace period post-transfer, but that's probably all there is to say on TUPE there. So we are coming up to 10:30 here. I am just going to pass over to Andrew. I'm aware that there have been some questions coming in, so it may be that we have a little bit of time to answer them. So thanks very much for listening, and I'm passing over to Andrew now. Andrew, you may be on mute.
Questions we have had, some of them are quite detailed, and give away that one of it is about the line drawn. You do can't provide evidence of work. So, okay, can you hit? Is that okay? So what we'll do, I think, probably the easiest thing, because we've probably got about 20, 25 questions, we will put together a Q&A sheet, which we'll circulate with the slides and with the recordings, because those questions are quite detailed, and we probably would like to be full answers. So I think probably if we can leave it there, but obviously what it has highlighted, difficult position for employers to be put in. Hopefully there will be some clarity from the Home Office about how you conduct right-to-work checks during the grace period, how you deal with the hire of European nationals. And of course, as soon as that guidance comes out, we'll sort of let people know what it says. But in the interim, we'll put together answers to the questions, circulate it. Hopefully there'll be some information in there that will be helpful to all of you to help you navigate this sort of difficult 6-month period. But thank you very much for attending, and I hope that you found the content useful. Thank you very much.